Good evening, friends. Today I'm going to speak to you on importance of date of patent for the purpose of infringement suits and the rights of patentees. Of course, this is a very simple subject. India has witnessed increasing number of applications for grant of patent, both from multinational corporations and foreign citizens and Indian inventors and innovators. Several ideas have been fructifying into, you know, commercially exploitable inventions, and therefore, naturally, awareness has increased. Government has also done a lot of publicity about the need for protecting one's intellectual property rights. India is now a matured nation. Amongst the matured nations, it is one of the very robust, we can say, IPR administering country. There a lot of weight is given to the intellectual property rights, and if there is any infringement, courts do come to the rescue of the owner of the invention or the intellectual property rights, so that what the law protects, what the law grants, what the law declares as the exclusive right of the patentee or the inventor is being administered by courts of law and the enforcement agencies in order to give thrust to the importance of significance of advantages of grant of patent. Now here, certain things have to be understood. In the law relating to patents, unlike the Trademarks Act or Copyrights Act, the inventor is supposed to ensure that there is some element of invention which is not obvious. Secondly, you should also ensure that it is not in the public domain. There is something copied, there is something which is obvious to somebody's mind, like putting two things together and getting a particular thing. This cannot be an invention, number one. Number two, you can't be going about telling in the public what you have done and how it is done. Publish it in the public domain, make it known to others that there is some invention, you have found it, and you inform the secret, you inform the specifications, configurations, compositions, methodology, all those things keep in the public domain, and thereafter you go and make an application, say that you grant a patent. It's not going to work. Therefore, one of the most important thing people must know is it cannot be so obvious that everybody can do it and then still you call it as a patent. No. Secondly, it is really an invention. It is really a great thought which has been brought about through a series of actions, and it has resulted in a very beautiful invention or innovation, and it is commercially exploitable. In that case, must not do anything about that to make it known to the public unless you have already applied for grant a patent. And therefore, date of application is important, because date on which the application is made is an important entry in the life of a patent and in the rights of a patentee. Date of application is important. Then there is another stage in the journey from the date of application to the date of grant. There's a big space, and that journey you will get the date of publication of the application as the first speed breaker. So date of application, then the date of publication of the application, where you have your application, an abstract of the specification, whatever you have filed, that will be published by the department, that is patent controller, that somebody has made an application to grant a patent and this is the abstract of his invention, so that you and me, whoever wants to oppose on any ground that it is not an invention, that specification is not complete, it has not been explained, all those objections whichever you want to make from the date of publication, you can always make objections until it is granted. And there are provisions under section 25(2) for objections to be filed post grant also. But suffice it to say, for this purpose, the date of publication is an important milestone in the journey because it is after the date of publication. Under section 11A, it says you have about 18 months prescribed for the purpose of making the publication of the application. So you make an application today, you wait for 18 months to get the publication of the application done. Of course, you have the power, right to make an application for expedited publication. And thereafter, what happens in the journey towards grant of patent is there will be an examination. The controller will assign the file to an examiner who is given probably some 3 months time to examine and present his objections, reports, findings, observations, and whatnot. He will do a lot of search. He will study whether there is any material, all those things. Thereafter, he goes to the controller, and the controller files a report. And thereafter, only it is found that it is fit to be granted a patent. Then it goes to the grant stage. But in between, there may be objections by any number of people, other co-inventors, other inventors, previous inventors, whether they have got grant or not, they can apply. Because if it is in the public domain already, if it is substantially copied from some other invention, there's nothing great about it. Any you and me can make an application and say, no, I want to object to the grant of patent to this particular application. Therefore, the journey is from date of application, you get date of publication, then goes for examination, then controller's report. In the meantime, there may be opposition against the grant of patent. Ultimately, it has to see the light of the day by grant of patent, which is where it is important is date of patent. Now, in this respect, let us just see only 2-3 slides and we'll finish this. It's a very interesting journey. So I think you are able to see the slide. So you can see there is a section 7 where you make an application, there is a date, note the date. Then there is section 11 here, which says date of publication of the application, which I said 18 months time prescribed under 11A. Of course, it can be reduced. You can file an application for expedited publication. Of course, you can also file an expedited application for examination, which means it will shorten the period between the date of application to the date of grant. Section 45, date of patent. Section 45 is important because the date on which the patent is actually granted will be different from the date on which the patent takes effect. So therefore, there is a date of application, date of publication, date of patent. And date of patent is the date on which it actually granted, but it goes back to the grant date from the date of application, as though on your first date on which you made the application, that day itself, the patent has been granted. So section 53, term of patent 20 years. So when it is granted, the 20 years will start running from the date of application. So these are all the important milestones in the journey of a patent. Now let us see what happens. I've told you about this 18 months period, which is prescribed time for publication of the application. So of course, you have, as I told you, the right to make an application for early publication and thereafter make an application for examination. All those things are to cut short the journey of the grant of patent. Very importantly, we must know what happens when a patent is granted and what this patentee is entitled to. The patentee is entitled to is a product patent or process patent, whatever it is, the exclusive right to prevent third parties who do not have his consent from the act of making, using, offering, manipulating, exploiting, and whatnot. Therefore, the exclusive right is what is important for you as an inventor or as a patentee. And that right is available for 20 years. Of course, in the initial journey from the date of application to the date of grant, a few years would have been lost. And yet, 20 years is fairly a long period, which really makes the legislative parliamentary significance granted to the patentee who is an inventor. Otherwise, what is the incentive for making inventions and then not being able to exploit it commercially with an exclusive right? Just you have to keep quiet, seeing a lot of people go about copying. No, that is not the intention. The inventor will have to get an economic interest which is sufficiently incentivizing him to do all the slog, labor, hard work, and come out with some invention and thereafter exploit it commercially, ensure that certain cash bills run at his home or office or wherever it is. So therefore, patent, whenever it is granted, the exclusive right is available. And as I told you already, the 20 years के लिए, this exclusive right can be exploited by the owner of the patent or the patentee. And when you talk about date of patent, we must remember the date of application is the date on which it will be patented. I mean, the commencement of the right as a patentee. When you can call yourself as a patentee is the date on which the application is made, but that date will be known to you only after it is granted. The second thing is there is another important provision, section 45(3). It's a very important provision. It says no suit for infringement can be filed before the date of patent, which means you have certain rights, that is exclusive rights. You can sue for infringement, but you can't do that until it is granted actually. Therefore, you have to wait. If somebody is doing something, you can't do anything about it until you really become the patentee and you are entitled for the rights of patentees. Section 45 makes it clear, subsection 3, that there can be no suit for infringement before the actually the date of patent, committed before the date of patent. This is important. The date of patent, what is the date of patent? Date of application. Therefore, if somebody has done something, is able to prove that he had been using the technology, process, product, etc. before the date of your application, where is the question of infringement? You can't make an allegation because on the date of application, you only know what you have done. Nobody else is supposed to be knowing in order to be entitled for grant of patent. Therefore, no suit for infringement if the alleged act of infringement is committed before the date of patent, and date of patent is nothing but the date on which the application is filed, which means it dates back to the date. And before that date, supposedly nobody should be aware of it is the important point. Under section 45(3), it's a declaration of law. But don't stop here. You must be able to remember there is section 11A subsection 7, which is very important. That is where the significance of date of publication of application comes. Section 11A says, on and from the date of publication of the application for the grant of the patent and until the patent is actually granted in respect to such application, the applicant shall have the like privileges and rights. Nowadays, you know that a lot of people use the words like very frequently during the course of their conversation also. But statute also uses this like privileges and rights in several places in other statutes, even in Companies Act articles and all, we have seen like privileges and rights. And here what is important is date of publication. Date of publication to date of grant, there is a journey. That journey from the date of publication, the applicant shall have, please remember the legislature uses the word applicant because on that date of publication he is not a patentee. Only when it date of patent he becomes patentee. Therefore, the applicant shall have like privileges and rights as if the patent for invention had been granted on the date of publication itself. So, as if granted basis, he gets the same like privileges and rights, which I said, what are the rights of a patentee under section 48. Proviso is important. Provided applicant shall not be entitled to institute any proceedings for infringement until the patent has been granted. Mind you, rights of patentee will come and sit on the head of the grantee of the patent, the patentee, only on the date of patent. That is, it has to be actually granted. So, until the date of patent, until it is actually granted, there is no right of patentee, and therefore, without right of patentee, there is no right to sue for infringement. Two different things between 11A7 and the proviso. Read the section 45, subsection 3. No suit for infringement for anything committed before the date of patent, because it goes back to the date of application. If somebody has done before the date of patent, no, it cannot be infringement. It will really be causing difficulty for the grant of patent itself. That is number one. Number two, from the date of application to the date of publication, nothing. No right. From the date of publication to the date of patent, yes, you have some rights which are called like privileges, like rights, as if invention has been granted patent on the date of publication itself. But that doesn't mean you are entitled to sue for infringement or commence any proceedings for infringement until the patent is granted. Therefore, wait for the date of patent, wait for the grant. From that date, you can sue, but you can sue even for the previous period because you have rights or entitled. Now you see what are these infringement rights. Proviso must be understood only in the context of those rights which are given to you in an infringement suit. Section 108. I will take you the reliefs that a court may grant in any suit for infringement of a patent is an injunction, either damages or account for profits. The court can also order for example, some ant pillar order or something. They say goods are seized and all forfeiture of goods. All those things can be done. So mainly it is a suit for infringement will include an injunction, which means you ask the defendant to refrain from operating the process or create manufacturing or selling, storing, stocking the product. Of course, you can take all the devices, materials, implements, tools, etc. also, because he doesn't need to, he will not be entitled to, he will not be able to keep doing the infringement, act of infringement. Therefore, see, when you look at this particular interesting field of law, which encourages inventions, should be able to understand the concepts clearly, understand the dates, which are the, you can say, milestones in the journey. The date of publication is an important milestone because that is the date on which confidently you can say the invention, some idea about the invention, an abstract, comes to the public domain, which means thereafter somebody copies, he had it, provided ultimately the grant is made to you. So therefore, there is no suit for infringement you can't file, but you may be having the rights which are like rights or like privileges as if the patent is granted to you from the date of publication, section 11A, subsection 7. I'm not able to see any case law on this aspect, but the simple point is that at that time when the publication is made, and if you find somebody is operating something that is not before the date of grant of, date of application, you may be able to, if you suspect that somebody has copied it, some information is leaked, somebody has done something which is constituting an infringement, probably even though you can't sue for infringement, you may be able to get a stay, or you can tell for maintaining proper accounts and reporting to you, and ultimately if the patent is granted, your right is very much a statutory right. You're invested with the right under section 48, read with the reliefs that you can seek in a suit for infringement under section 108, and read with 11A, from the date of publication itself that right accrues to you, though you can't sue for infringement. Therefore, the concepts must be understood, the dates must be understood, the journey must be understood, and the need for not doing anything in the public domain prior to making the application is a very important thing, because if it is already in the public domain, you can't get the patent granted. Moreover, you can't, even if it is granted before application date, if something is there is no question of infringement. Right? This is the beauty of the entire sequence of things specified in section 7, section 11, section 45, section 48, and section 108. So this is what I thought I'll share with you on the grant of patent and the right of patentees and the eligibility or entitlement to sue for infringement. How does it work? And from the date of publication, some rights are there which are better than no rights at the date of application stage. So Thank you very much. And if you have any queries, you can always reach out to me. Thank you.